Hello, it's 2 o'clock on Friday, the 16th of September 2022, and we're on day 5, which is the closing day of the HCCH CODIFI conference. Thank you for joining us, and welcome to those of you who've just joined us. You're just in time for the Digital Economy Framework's closing session, and this is the session that will actually close off the digital economy tracks of this conference. In keeping with the digital economy and the technology focus of this track, we've chosen to do this closing panel as a concurrent design facility. And we have then a panel of experts with us live. But before I explain the concept and the format that we have, let me introduce to you our panelists and experts for today. We have with us Anna Veneziano, Deputy Secretary General of the International Institute for the Unification of Private Law, UNIDOR, sister organization of the HCCH. Welcome, Anna. We have José Angelo Estrella Faria, Principal Legal Officer and Head of the Legislative Branch of the International Trade Law Division of the Office of Legal Affairs at the United Nations, UNCITRAL as well, one of our sister organizations. Welcome, Angelo. From industry and associations, we have Mr. Silvan Andermatt, who's Director at the Swiss Finance and Technology Association. We have Mr. Anurag Bana, Senior Legal Advisor at the International Bar Association. Welcome, Silvan and Anurag. And we have a host of professors with us to bring all the academic and really insightful comments to this panel. We have Matthias Haentjens, Professor of Law at Leiden University, Kelvin Low, Professor of Law at the Faculty of Law, National University of Singapore, Professor Carla Reyes, Assistant Professor of Law at Southern Methodist University, Dedman School of Law, and Professor Teresa Rodriguez de la Heras Ballell, Professor of Commercial Law at Universidad Carlos III de Madrid. Welcome to all the panelists. Now, while I may perhaps just run through quickly the format that we're hoping to do today, I'm going to ask the panelists to unmute themselves and keep their cameras on throughout the entire session, unless we have a dog barking in the background, in which case we do expect the dog to show up on screen. But otherwise, please have yourself unmuted. This is to allow for rapid fire response and reaction if you have to one of the other panelists' comments. For our audience joining us today, we're going to do this in the format of a concurrent design facility, a CDF. And a CDF is a work methodology that leverages concurrent engineering, which is a practice that calls for a collaborative and agile approach to designing solutions instead of having individuals and entities work on their own in silos, and instead of having consecutive iterative steps. Now, concurrent engineering has been proven to be more efficient, more accurate, and more effective than traditional sequential design methodologies. It has therefore been rapidly adopted by technology-based institutions and organizations like NASA and Boeing, looking to incorporate interdisciplinary expertise and multilateral perspectives into problem solving and solutions design. So the objective of this session is to rapid prototype a proposal for potential future work in the form of some sort of private international law instrument concerning the digital economy. We don't know where we will land, but we ask the participants to critique and propose and refine a conceptual framework for the most desirable features that can feasibly be implemented and agreed upon at the international level. We ask the participants of this panel to consider the instrument's purpose in answering the core questions of private international law, so jurisdiction, applicable law, recognition and enforcement, and international cooperation, keeping in mind that this instrument should be technologically agnostic. So that's the idea of this closing session. You know our panelists now, and perhaps just to start off with an easy softball question, having heard the various sessions of the Digital Economy Frameworks track this week, what would be your main takeaway from this week? Anna, let's start with you.
Thank you, Jerry, but I know we have a very tight framework, but allow me to use at least a few seconds to thank our colleagues in fact at the HCCH and particularly you for organizing this event, which is really innovative and thought-provoking. So thank you very much for the invitation. As far as the question is concerned, if I'm allowed a broad takeaway from the UNIDRA's experience, first, it is evident that from this event that the issues regarding the digital economy are actually pervasive and have to be taken into account in many different commercial law areas to a broader or to a lesser extent. And we see that also in UNIDRA's work, not only the digital asset project, but also, for example, the model law on warehouse receipts we are developing with UNCITRAL and the project on enforcement and so on. And the second point is that when developing a substantive law framework, be it general or more detailed, it is not a novelty that the questions regarding private international law are inescapable and have to be considered to complete the framework. But this is particularly compelling in the area of digital economy because of the lack of a clear answer in many domestic laws and the need to find some level of harmonization in view of the global reach of the digital economy. So just to conclude, this is why we have really welcomed the active cooperation with the HCCH and are happy to continue to share and to enlarge this cooperation for the future.
Thank you, Anna. You speak directly to my heart. Angelo, let's hear from you.
Thank you very much, Jerry. And like Anna, I'd also like to begin by thanking you and actually congratulating you for the organization of this conference. I've learned a lot this week, and I think I've covered most of the topics that are in everybody's minds this way. And as the conference was thought-provoking, I'll begin with a thought-provoking takeaway. I would say two things. One is that there is more than hits the eye in all this discussion on legal issues of the digital economy, especially applicable law, but also not everything is new under the sun. So it's a combination of the two things. But one thing that seems obvious to us is that in many respects, the digital economy is challenging some of at least the conceptual framework that have been applying both in private international law and private law rules. Now, we at UNCITRAL have always traditionally been rather conservative in the sense that our work begin with the model on electronic commerce, the model law on signatures, the model law on electronic transfer of records, and the most recent model law on identity management systems. We have been very much concerned about avoiding a duplication of legal systems, that is, preserving the unity of the law. Now, the challenge that we're facing is that at this day and age where we can anticipate a phase out of the old negotiation patterns, right? And moving towards this more dynamic patterns, including by GLT and blockchain. And that the question is, can the law stay the same, or would that require also substantively different provisions? And I don't think we have the full answer yet. And our inclination would be, let's try to stretch the old law as much as we can to make it still work. So that will be my takeaway so far. Thank you.
Angelo, thought-provoking as usual. Silvan, what's your main takeaway for this week?
Thank you very much for the question and for organizing this stunning conference. And I've seen so many very interesting contributions so far already. And my distinguished speaker colleagues also have many specific angles to bring to the table here. And they will be arising very important topics. And for this new technology, especially, I'm interested in DLT blockchain. And as the speakers kind of already mentioned, there is a need for legal harmonization and further analysis, for instance, with a taxonomy of digital assets and some clarification of the references for property law in case of digital assets. And also like further understanding of implications of custodian, issuers, network, and all the kind of the participants in the ecosystem that is involved in this in DLT blockchain. And in my view, we should continue to embrace every opportunity to share knowledge about distributed ledger technology with legal professionals in order to foster kind of the implementation and adoption on one side and the legal certainty on the other side.
Brilliant. Thank you so much. Silvan, let's hear from Anurag.
Thank you, Jerry. And I'll just basically echo what everyone has said before me. It was a fantastic week, and I found the sessions to be very eclectic. There was very eclectic discussions and very fascinating sessions. So I feel I would, for me, the takeaway would be the issue of access, process, and applicability. I feel these are the three issues which probably will be important from a certainty perspective, and looking at access, applicability, process applicability in connection with identity would be another aspect which we just need to remodel it in a way that we focus not only on the regulations but also on the principles part. So which I feel is what I've seen and what I've heard during this week. So yeah, that's what I would say is the takeaway from my end.
Thanks so much, Anurag. Let's go to Matthias.
Thank you so much. And the problem with this type of questions always is in a round table that your predecessors have pretty much always said all the important things that you wanted to say. So what I will do is keep it very short and say in my own words what I think most of my predecessors have already said, beginning with saying that I think indeed certainty in here is leading principle, and from that perspective I wholeheartedly concur with Angelo when he said that we should first try to see how we can apply traditional existing rules of law. At the same time, of course, and that has already also been said, is that we have here also new developments, and then I think mainly in the where it regards the assets that we have, not so much digital economy as a whole or smart contracts or the like, but mainly the type of assets that we have, the new assets we encounter with distinct features, which are sometimes difficult to fit into existing rules. So there we need to find new rules, again, hopefully by first looking at the old ones, and preferably and maybe necessarily on a supranational level, which has also been said already, but because of the nature of the asset and the cross-border aspect of international commerce, I believe it is imperative that we try to find new rules on the supranational level. And also for that reason, I wholeheartedly congratulate the HCCH with this conference and this initiative. Thank you so much.
Thank you, Matthias. That's very kind. And now we're going to turn to some controversy, hopefully. Looking at you, Kelvin, and then Carla. But let's go with Kelvin first. Let's blow my mind.
Thank you, Jerry, for inviting me to this closing panel and for organizing CODIFI. It's been a fascinating week. I've learned a lot. I suppose what everybody else before me has said is completely correct. There's no need to reinvent the wheel for a lot of the issues that we face in this new digital economy, but there are certain problems that are quite peculiar to DLTs, blockchains, smart contracts that we need to wrap our head around. I suppose my main, I don't know if I would call this a takeaway, but I think that we need to address the elephant in the room, which is, the meltdown over the last couple of months. There has been a lot promised by this digital economy. It hasn't really delivered very much. There's been a lot of fraud, a lot of scams. There's a lot of, insolvencies. So I wonder whether we might want to focus on things like consumer protection, right? Insolvency, rather than, say, custody. These are facilitating, and I have no problem with facilitating the digital economy, but I think we need to deal with the harms that has already been done. Right.
Thanks, Kelvin. You never cease to impress me. Let's go to Carla.
So maybe this is where the controversy comes in. So I tend to agree that there aren't actually that many new issues in this space, and I think that the more so I have a long view, right? I've been in this space since like 2011, and a lot of the things that we are talking about as new issues are things that industry has already found workarounds for in connection with their lawyers. And I get nervous when we talk about creating brand new rules for the brand new economy, because it's really not that brand new. And they've figured out workarounds, and I hope that we, in working through these very fascinating issues, which they are, clearly I've been working on them for a decade, we don't mess up what people have already come to expect in commerce in this area. I also am not perhaps as concerned by the recent meltdown as others, right? Here's the controversy, because I expected it, right? There's no way Bitcoin could have stayed at $80,000 for forever. Like that's crazy. And if you've been in the space long enough, you will expect these ups and downs, giant swings. And I don't know, the internet went bust before it became a real thing. So should we really be so concerned at this early point? I don't know. So I think my takeaway from the week is like that we should exercise caution, that we, the lawyers and the lawmakers of the world, can really mess this up in the long run if we're not careful. And really the issues, not all the issues are new at all. And we just have to, as Angelo said, figure out how to expand or see if the existing laws can stretch to cover what's happening. And in many cases, people have already figured out how to do that.
Brilliant. Thanks, Carla. Let's go to Teresa.
Thank you, Jerry. Thank you very much for the invitation. I'm delighted to be part of this enticing joint exercise and conversation. So 3 takeaways. The first one is many of the challenges, if any, that we are identifying in the digital economy, they become or they arise from the convergence of different technologies. So we have to be extremely careful, not only of being technology neutral or technology agnostic, but to avoid any kind of reaction that is technology specific, because many of these new situation or challenging situation come precisely for the combination of a multitude of technologies. That leads us to the second point, challenges. As Angelo mentioned before, there are challenges, but of different nature, different intensity, conceptual, substantive, but also sometimes purely a practical application of existing rules. And that means that these challenges require attention, but different kind of attention. And this is precisely the third takeaway that is completely in agreement with the previous comment, this idea of how we have to solve and approach these problems, probably with a multiple layer, a multiple stage approach. First, to make a diagnosis, what do we have and what is still working properly? Second, try to see what are the gaps or what are the problems that can be solved simply by explaining, interpreting and adding explanation to what we already have. Third, if something new is needed, maybe let's start with principle. And only at the end of the process, let's produce rules where it's absolutely necessary. Rules that have to be harmonized at an international level.
Great. Thank you very much, Teresa. Does any one of you want to react before we move on to the next question I have for you?
If I can just
Please,
respond
Kelvin.
to something Carla said. It's not early days. I think the early days argument is getting old. It's been more than 13 years. Everything that they've promised, hardly anything has materialized other than a lot of harm. So I think we need to stop with the early days argument. I think the comparisons with the internet are wildly off the mark. The internet had many use cases before the dot-com bubble came about. Email was being widely used. There were actually online merchants already. It's just that we kind of got caught up in the hype. Whereas, you know, for this space, much has been promised in terms of disruption. As far as I can see, nothing has disrupted any of the mainstream traditional finance yet.
So I'm going to react to that. I strongly disagree. And I think that if your focus is on disrupting traditional mainstream finance, that you've missed the mark of the blockchain industry entirely. That's not the only use case. And it's indeed the other use cases that are flourishing, the ones that nobody's paying attention to, that we can ruin entirely if we just focus on the financial industry aspects. And that is where I hope we exercise caution, that we don't just focus on the one that gets the most hype, like you said about the internet boom, but rather that we focus on the entire industry, all of its use cases. And yes, they hype it up. It's advertising, like that happens in every industry, but it is what it is. And anyway, I'm just not as hard on it, I suppose, as you, and that's fine.
Thank you very much. My takeaway from this, at least, is that we need another panel with Kelvin and Carla on it. We'll duke it out in a separate panel, perhaps. But thank you so much for your insights there. We will actually reach out to you, Kelvin and Carla, for a bit more on that. But in the interest of time, let's move on now. In your opinion, then, what is the main private international law questions? So applicable law, choice of forum, party autonomy, limits on such autonomy, jurisdiction, recognition, enforcement that might or would arise in the digital economy in whatever form, whether it's DLT or not. And maybe let's start from Teresa this time.
Thank you, Jerry. I believe that to some extent, all the traditional PIL questions are somehow affected by these challenges we are discussing now, probably with diverse intensity and for different reasons. But let me just provide you at least two main examples. On the one hand, applicable law and jurisdiction. It is clear that these kind of technologies are asking us to reconsider the traditional connecting factors and conflict of law principle. And that might be a case of reconsidering entirely the reason, so the conflict of law that we are using, or could be simply a practical difficulty, a practical complexity in identifying the way to apply a rule that we still believe that is adequate. For example, location, that is probably the best example that we can use in that regard. But also, if we take a look at the other PIL question, for example, autonomy, the limit of autonomy, even if many of the challenges are not impacting on PIL traditional question, however, it's impacting on other aspects and therefore indirectly affecting PIL. For example, validity and enforceability of choice of law in a coded contract, in a smart contract, to which extent is enforceable, is valid, is international recognizable, for example, or to which extent we could consider that parties are exercising their autonomy when they are using electronic agents or autonomous decision making. So in my opinion, all these main traditional questions are affected with different intensity and therefore probably requiring a different attention from a legislation point of view.
Thank you, Teresa. Carla, do you agree? What is your opinion?
I agree. I think that party autonomy and limits on autonomy is one of the key issues, in part because I think that's when we all react and we're like, "What? It's new issues," because the space wants to stretch the idea of how far their autonomy in private ordering can reach, and we worry, wow, but what about the law? What's the role of the law? How do we control it? So anyway, I think party autonomy and the limits on that autonomy is one of the key issues because key interest in the space. How do we claw back our autonomy and retain it in new and interesting applications through technology? I also tend to think that because of that, issues around applicable law, jurisdiction, and I think the least implicated is enforcement. I actually think there are far less issues in the enforcement context than most people tend to think there are, for reasons I think Drew, Hin, and I discussed in our panel. But I think the others, particularly applicable law and jurisdiction, catches people's attention because of this idea of stretching the notion of just how far can we go with this emphasis on party autonomy.
Thanks, Carla. Kelvin?
Jerry, gonna disappoint you now. I absolutely agree with everything that Carla said. I think party autonomy is the big question that we really need to answer, because in this digital economy, there is actually tremendous inequality of bargaining power. Most of the terms are actually set by the big boys. There's tremendous concentration of wealth and control in the digital economy. I mean, it makes the United States look communist by comparison. So party autonomy is the big one for me.
Thanks, Kelvin. You never disappoint. You never can, I don't think. Let's go to Matthias.
Thanks a lot. I think I agree with what has been said before. I think where the problems lie from a legal perspective rather than a practical one. I think that's most pressing in applicable law issues, where judges mainly in insolvency cases have struggled with the qualification of the assets. So there I see an issue, and by solving that and then also trying to find a appropriate conflict of laws rule there, I also see that, and I think that party autonomy here is the pressing concept, but maybe in a slightly different way than Carla and Kelvin just mentioned. I think that if we consider that most digital assets now are held through intermediaries, when we start thinking about conflict of laws rules where it regards the applicable law, and we come to the conclusion that party autonomy here plays a role or should play a role, then that would be contrary to what many, especially in continental Europe, jurisdictions traditionally have as a conflict of law rule where it regards property law issues. So introducing party autonomy here, which I personally believe would be a good thing, would be a novel development from the perspective of many traditional civil law jurisdictions.
Thank you, Matthias. Anurag?
I think that's, well, I would agree with party autonomy as something which is definitely will make a huge impact, because I feel the problem is, especially the critical parts are the jurisdiction and recognition and enforcement. but they are tied in. Jurisdiction is tied in with recognition and enforcement of laws. So party autonomy definitely could get significantly impacted, even in an underlying collateral contract outlining applicable laws and any other resolution matters. So if it's not finalized alongside the digital contract. So yes, party autonomy is something which will probably be something that one would need to look into from a global perspective. And yes, jurisdiction is what I think is important.
Thank you, Anurag. Silvan.
Thank you very much. So it's probably natural of the panel that getting a bit difficult to add something if everyone has answers already.
We can also just agree.
I would just stress that maybe the whole situation is because or the appearance of the issue that we are trying to solve or address here, kind of that we identified, is appearing because on the one side you have some innovation where the people are driving to push boundaries, and on the other side you have a law which tries to keep things in check and have something which is a level playing field for everyone. So I think it's interesting that we try to accommodate both sides and try to give certainty on the one side and trying to still innovate and push boundaries, something which is by definition already towards going something which is unknown. So the two things need to be balanced a little bit, and I think this is getting this pressure that we are now trying to solve here all together.
That's actually really insightful, Silvan. Thank you so much. Now, Angelo, a lot of people have agreed with you. You can agree with yourself too, but I'd like to hear what you think on the specific question.
Well, apart from everything that I agree with, I'd like to point out two things that where people have not focused so far. I mean, I heard some mention of it. And those are the things that I don't think, let's put that way, that I don't think that are that important. And I begin with, say, jurisdiction and recognition enforcement. I think jurisdiction, is apparently more important than it is. But at the end of the day, there will be always an entity against whom we want to enforce a contract and we want to enforce an interest. And there will be jurisdiction rules that will provide an answer to that. The problem is to find out who that person is and which country actually should have. But that's more of a practical difficulty, I think, than really a legal issue. Applicable, I think it's a more complicated thing. And then to take the example that Matthias mentioned, the treatment of digital assets and insolvency, then you have two layers of difficulty. One is that we don't know exactly what is under which law we're going to qualify the nature of that asset, because the lex recite not necessarily works well in this context, unless you can rely on a prima principle or another similar principle, but that depends on the business models that the party have used for that transaction. So we have that layer, and then the second layer is substantive law, is that the qualification is not uniform. And we saw that with intermediated securities in countries that are as similar as the UK and the US in the Lehman Brothers case, right? So, but some of that experience and the lessons we learned from that can be transposed into here, but some things are really, I think, location and lex recite is really a point where we have stretched the law to further than it can possibly answer the question, because it becomes in a way irrelevant. But the others, I don't think that are that important. And the last thing that I just mentioned on party autonomy, I suspect that part of this, whether or not we like the outcome, but part of this will be addressed by would I expect to see more regulation of the market coming from governments. I'm not saying that that's, Carla, I'm not saying that that's a desirable result. That's what I'm saying, that's what I'm advocating, but I expect that governments would regulate more than market because of the monetary, financial, and other implications that has, because of money laundering concerns and all these other regulatory interests. And part of that would already provide some I would say parameters for a party autonomy, or at least one would give us an answer of how far it can go. And then the last thing is there are things that party autonomy would not be always capable of addressing it. That is the proprietary nature or not of an asset, because, you know, if you choose by agreement that it is property, then you are indirectly engaging the state to defend this property through the state machinery of property rights. And that's the question, whether you can do that by contract. I'm not saying I'd advocate more regulation, I'm simply saying this at a certain point would just be inevitable. Thank you.
Thank you, Angelo. Let's round this up with Anna.
Thank you, Jerry. Well, I can be very brief because I think many of the things I would have said have been said. If I look at it from our experience in trying to develop a substantive law framework, the applicable law was the center of attention. The importance to consider party autonomy that was also mentioned at different levels, because you have the level of the single contracts, you have the level of the platforms, so that was also something that was discussed. And the limits to such party autonomy, should they be the same for those situations, or should they be different? And this is, I think, particularly relevant in an area where domestic laws, with their somewhat different approaches, will probably still continue to play an important role. So we are not looking for maximum harmonization here. So.
Thank you very much, Anna, for that. Now I'm just going to quickly move on. We had a session this past week where in his contribution, Professor Andrea Bonomi suggested that it will be interesting for the HCCH to work on future projects, facilitating the recognition of decisions rendered involving blockchain systems. And he specifically said possibly in concert with UNCITRAL. Now, I know Angelo's just spoken about it. I'm going to give him the last word on this. So I'd like to get the reactions perhaps. First from Kelvin.
So I think I agreed with Carla earlier. I don't think enforcement is a pressing issue. So I think you could better spend your energies on other more pressing issues than this. That's my take.
Thank you, Matthias.
I agree.
Teresa?
Thank you, Jerry. I would say just in addition to this discussion of the adequacy or the convenience of adopting this kind of project, I think that's something that we have to be very careful in ensuring, in distinguishing, is what is related to blockchain as, let me use this word, infrastructure. So the medium, the structure where we conduct certain activities. And then what are the problems that using this particular medium, infrastructure of technology has on the particular situation with legal relevance that we are talking about. So probably this is a project or a proposal for a project that gives us an idea of how this distinction is fundamental. So what is really important here? The fact that blockchain has been used in the decision making, has been used in the way of reporting or storing this particular decision. The fact that no central decision maker has been used in that particular decision. So I think that just talking about involving blockchain the system is not giving us exactly what is the real problem that from a substantive point of view we have to deal with. So just to give a framework of what kind of issues, in my opinion, I think we have to bear in mind.
Thank you, Teresa. Carla.
So I tend to agree with Kelvin and Matthias, but I think that the recommendation itself tends to reflect a comment Matthias in the last question, which is that a lot of assets now are held through intermediaries. I think that to the extent you're going to see litigation, at least in the near term, and right now even, that would require enforcement of judgments related to blockchains in whatever way, it's going to be intermediaries, like traditional entities that are fighting with each other, and therefore the decisions and enforcement of those decisions aren't that terribly new. It's just regular entities that just do new stuff, right? I think when we start to think of the really interesting issues that we want to create new rules for or whatever, a lot of those are edge cases, because you're assuming that people who, not you personally, but we in generally, are assuming that people who interact on a peer-to-peer basis, who are really doing the sort of what I would think of as the cutting edge work in the technology space anyway, that they will be the ones suing each other. And I just don't know that many of them who would do that, to be honest. They're trying to think through other sort of alternative dispute mechanisms. Anyway, so I tend to think that this isn't as big of an issue, but in part because in the near term and probably in the long term even, the people who are going to be needing frameworks like this are just traditional entities that just happen to work in a new space.
Silvan, do you agree?
I tend to agree with my estimate colleague here in the panel, and on the other side, I always think that kind of further investigate an issue may bring up some unexpected twists or so that could lead to some problems that we did not yet recognize or did not see. Maybe we should give it the benefit of a doubt and at least keep it in our mind to follow up a bit later in time when we see more cases.
Voice of reason, Silvan. Anurag, do you agree?
Yeah, I think it's a great suggestion. The fact that there is a lot of discussion going on from a international perspective on digital sovereignty coming in, and then there are bilateral investment treaties also now, by the way, discussing about a lot of issues of automation and data transactions. So UNCITRAL has really done a lot of work on the legal taxonomy, legal terms work, and HCCH is definitely in that strong position to be able to work together with UNCITRAL. I think it's a great suggestion, and definitely I feel it's workable.
Thank you, Anurag. Anna?
So, well, we're very happy to see the bilateral cooperation between our two sister organizations growing, and we are not jealous, or maybe not too jealous, but I will not comment on this in particular. I have only a very short question more than a comment. I was wondering whether there could be a risk in focusing on a particular type of technology. I think this links to what Teresa was saying. Since we are struggling to achieve a sort of durable kind of regulation or instrument, and to find a kind of technological neutrality or agnosticism, and to which extent this can be achieved. So this is more of a question than a comment.
It's a brilliant question, Anna. You're always the voice of reason, really. Angelo, you do have the last word.
Thank you, Jerry. When I mentioned before, for instance, that I don't think that jurisdiction is such a big issue, Carla actually had us illustrated that brilliantly in her last comment. At the end of the day, these are entities of the quote-unquote old world. They're just doing business in a different environment. The law still assumes that the subjects of rights are natural persons or legal entities, and I don't see the law giving rights to robots or DLT systems. Not that soon. At least I'll be dead before that happens, probably. So I think this is we're talking more about a practical difficulty related to anonymity and things like that, a difficulty of locating parties, but at the end of the day, the system is there, and when there is a litigation, people who know where to sue. Now, we've heard Bana mentioning that the taxonomy that we're doing at UNCITRAL, and one of the elements includes exactly dispute resolution in the digital economy, including by DLT. And even though there's some questions that would appear to be very novel, for instance, the idea that, because in a blockchain dispute resolution, you may have a dispute resolution that is not by legal terms, but as a matter of encouraging an economic best practice or best behavior. That is not by itself incompatible with arbitration. Just think that you can have arbitration by law, or you can have an arbitration by equity, right? The parties can agree on the basis. So if you apply the notion of party autonomy properly, it should accommodate all of this. Now, it could also accommodate a system that is entirely automated. You just have to think carefully, because, well, then you have how to understand reasoning, the requirement that an arbitral order has to be reasoned, how to transpose that to an environment. But if the premise is the parties are adjudicating their disputes by a mechanism that they voluntarily agreed to set up and abide by, the current framework should in principle accommodate that. So that said, it is certainly interesting to look into these questions, and we are looking into these questions. I don't expect a brand new branch of the law to come out of it. Thank you.
Thanks, Angelo. Anyone wants to react further before we move to another session?
I just want to say,
sorry.
I just want to say, discount the possibility of robot personhood just yet. What if the robot is the corporation? I'm just going to say, right? So there is a lot of literature looking at this idea of corporate personhood that enables AI personhood, sort of. So just, you know, don't discount it too far. But even then, it's a traditional entity that you would know what to do with. That's the kind of the point.
And if I may, Jerry, just adding on this idea, even if we decide not to use this electronic personality or electronic personhood as a fiction, as legal fiction, still we have to decide on how to allocate legal effect arising from action or decision adopted by automated decision making. So there is still this kind of decision that from a legal point of view has to be adopted. But even though talking about the use of blockchain system per se, is not entailing neither the use of artificial intelligence nor the use of automated decision making. So in a way, blockchain system for me is just the environment, the medium, the infrastructure, not more than that. With the problems that may arise from that, but definitely not entailing many other technologies that are stacking on.
Thanks, Teresa. Anyone else?
Yeah, I think.
Yes, Matthias, of course.
Yeah, thanks. I think I agree. And building on what Angelo said before, I think that where regulators are now increasingly implementing regulations, they tend not to regulate private law matters. So I think there's still work to do. But where they do are very active, and I believe rightly so, is pressing for entities working in this area to adhere to traditional rules of having a corporate seat, etc. So, which of course facilitates also from a practical perspective, the application of traditional private international law issues. So I think here regulation and the activity of regulators interacts with the legal issues.
Yeah.
Sorry, Anna, go ahead.
If I may just intervene very briefly on this, I think in the end, we might expect regulators to look at, as was said, at issues of transparency and at issues also of access to the market, as it has been said, of the entities, and probably not necessarily focus on limiting the possibility of parties to shape their agreement. But that might vary depending on at what level you are. So that was my previous comment.
Thank you, Anna. Carla.
Yeah, so going back to this regulation piece, because I know I made faces when they said it's inevitable there would be more regulation. I don't disagree if it's inevitable there'll be more regulation, but my concern or my hope for the regulation is that at some point regulators understand the technology well enough to actually target the regulation to the problem that they want to solve. So reactions to things like, well, it's crypto's fault that there's this recent collapse. Well, not really, right? The entities involved in the recent crypto collapse were traditional entities doing traditional market stuff, and they just overstepped and nobody was paying attention to them, right? That's like, that's not crypto's fault. And so I just hope that when we regulate, that we understand the technology well enough to separate out which activity is actually the risky activity and recognize that it's not the technology in and of itself. It's just a technology, right? It's what people do with it that causes the risk.
Yeah, I think if I may, I think that's a very important comment here, Carla, and also highlights some debates that we've had, namely the distinction and the difference between regulation and private law rules, where regulators should really focus on risks and market failures, and therefore really have to understand and define the precise assets and entities that pose risky behavior where risk materializes. That must be contrasted and distinguished from private law rules, which are of a more abstract level, and of course also may have policy goals behind them, but are far more abstract and could be, and then I tie back to an earlier discussion, could be technology and maybe should be technology neutral as much as possible.
I think in that regard we can also learn from, just from normal regulatory, because really going for a technology neutral approach is I mean, it's not so, I mean, usually it works out pretty well, at least in Switzerland, it worked pretty well. So FINMA, the Swiss Financial Market Authority, started with some regulatory clarity on producing guidelines and so on, just very early, like in 2017. And even the Swiss government analyzed the Swiss law and framework, and I mean, they come up with the conclusion that just some punctual, very specific intervention would already be sufficient to tackle the whole new technology. So I think that would be pretty convenient if we could stick to the already known rules and everything and just amend it if needed at all, then very punctual and specific on brief intervention to the point.
Thank you, Silvan. I'm actually going to stick with Matthias for a bit, if you wouldn't mind, and move to another session that he was part of, which was a fireside chat that was recorded in Rome just earlier this month or year, actually month. And in that chat, Matthias sat with Professor Louise Gullifer, and they discussed some matters, including a suggestion that the establishment of a completely new supranational code to deal with digital assets is unlikely, which is what we've just been talking about on this panel. So what the conclusion was, I think, was that rather private international law rules and existing domestic property law is likely to be amended. In their conversation, there was also the question of whether the establishment of rules that increase predictability and certainty to determine applicable law that is based on generally accepted conflict of laws principles should be it, and how those rules should distinguish between contractual and proprietary issues. I will encourage our audience here to perhaps listen to that full fireside chat. It's a very insightful and very interesting chat. But Matthias, do you have anything else to add there? Either maybe through the unit law principles or something else in the contract between investor and custodian or so on?
Yes, thanks a lot also for your kind words. Make me blush. I think important to distinguish here, and that's also what we've really come to realize during our discussions at the UNIDRA project, is to really distinguish between the asset itself, the digital asset itself, and the asset to which it may be linked. And this is something that sometimes became blurred, I think, in the previous sessions. For instance, the discussion of appropriate conflict of laws rule where it regards currency. I really think that if we look at digital assets, that must be distinguished from a currency or whatever other asset that may be linked to the digital asset. So I think that would be something that I would add. First thing. Second thing would be, and then building on also what Angelo said, how we can maybe learn to look at the discussions we've had in the context of intermediated securities. And I think there we have a very important issue, especially where it regards the applicable law to property law matters in that context. And it's especially in that context that I think that we may need to stretch the rules a bit further and allow for more party autonomy than in several jurisdictions have proven to be found acceptable precisely in the context of intermediated securities. So I think this new type of asset would require us to go even a bit further than has been achieved in the context of intermediated securities.
Thank you, Matthias. Perhaps reactions from the other panelists. Shall we start with Silvan?
Yeah, I agree with his view, so I kind of have not much to add on this one. I would, if someone wants to offer a critical opinion, I think it's difficult to find some points, but I would appreciate it.
Thank you, Silvan. Anurag, do you have something critical?
No, I basically just, I think one of the challenging issues is to imagine the introduction of a supranational code. If looking at that aspect, I can see there's a reference to supranational law, because there are many jurisdictions now coming out with their own sets of how they understand the situation, whether it's the UK jurisdiction task force, whether it's the Swiss blockchain, looking at whether it's a legal tender or not. Looking at crypto, and also Dubai blockchain or Singapore. There's this huge range of understandings that are coming up, developing, and even sharing. There's a lot of sharing of that information coming around. So there needs to be some kind of a consensus in terms of looking at the supranational law concept. There's a lack in the consensus as to how the global markets and the economic situation and the systems would effectively function on the platforms in a manner that the world not cause any significant legal or financial ramifications as such. So I think that's one area which probably would need a bit of a focus. That's what I think.
Thank you very much. Thank you. Kelvin?
Right. I think I would push back a little bit on what Matthias was suggesting, as in, pushing even further in terms of party autonomy, because we've seen a lot of abuse of, their control of the terms by a lot of these custodians. So I know Coinbase, for example, is being sued on the basis that its arbitration clause is invalid, and I think they are going up to the US Supreme Court. Basically, every single custodian that I know of excludes the investors' rights to bring class action lawsuits. So I'm not sure we want to encourage that. So I would rein in the party autonomy side.
Thanks, Kelvin. Teresa?
Thank you, Jerry. If I try to think what would be the content of a possible supranational legal framework for digital asset, what is really difficult and I think non-advisable at all is the idea of including in this supranational framework categorization, legal categorization of digital asset, replacing or contradicting what domestic law is already setting out or stating for the equivalent of this digital asset in the non-digital world. So that would be extremely challenging, probably not having the necessary consensus of the state, because that impact directly on the core of domestic legislation in the part of contract law, because there are many contract law aspects that has been already mentioned. So what is the relationship between the issuer and the holder, or the custodian and the holder? So there are contract aspects, but definitely property law aspect as well, that they are probably very much linked to the sovereignty of many states. So supranational framework has to assume that limitation and may help in first providing precisely clarification or clarity in international private law aspect that can help a lot, assuming this difficulty of applying the traditional connecting factors. And secondly, probably providing a guide, providing guidance for the state to better understand how to fit into the existing legal regimes, the new tokens, the new crypto asset, the new digital asset modalities. So that is the kind of supranational approach that I consider more probably desirable at this stage.
Thank you, Teresa. Carla?
So I think I agree with Teresa to the extent that she's suggesting that additional guidance is needed sort of everywhere. This is me being controversial again, but I don't think we need as much consensus internationally as everybody thinks we need. I don't think there needs to be this like giant, we're all on the same page kind of, thing. It doesn't bother me as much that there are a variety of approaches legally across the world. There are for everything, like that's not new. I think what's bothering us about it is that some states, some jurisdictions are behind others in their development of those principles. And so maybe it's more difficult to have certainty in those jurisdictions. Like, that's part of business. Like, where are you trying to put lawyers out of work? Like, what's happening? Anyway, it just doesn't bother me that there's uncertainty. I think that's because that's the realm of transactional lawyers. It's your job, right? Is to find the uncertainty, manage it for your client, and cover off the risk. I would also say I wouldn't base discussions around party autonomy and whether you can extend it or not in the private law context in reference to the stuff that's happening in the United States with arbitration, because that's it's a wholly separate issue. The arbitration policy in the US is based on the FAA. It's about federal preemption. It's this whole other doctrine of law that doesn't necessarily tie into the private law principles that Matthias was referencing when he was talking about party autonomy. So I would just caution on keeping those issues separate. I don't disagree that it's a problem that stuff's always in the arbitrate in the terms of service, and that people don't read their terms of service, so they don't even know until it's too late. But But I do think that's a bit separate from, at least in the US context, from the stuff that Matthias was talking about.
It seems like a really good time to drop the hot potato onto Angelo's lap.
Thank you. So I'll try to cool off this potato a little bit by framing the question the way I understand it. I understood the question as we are concerned only with private international law rules for digital assets, right? And there I would agree that there is some guidance needed to what extent current law covers them and where the limits are, and perhaps there will be a niche, I suppose, probably the endogenous digital assets that there might, the question is whether the current rules really cover them adequately or not. Because you let the lack of location. There will also be the question for the exogenous digital assets, to what extent the location of the underlying asset by itself would trigger the application of a particular law, and whether that would work with the fact that the token is being negotiated in a particular platform. Now, this is how I would say, and I think, yes, there's guidance is needed. Now, I would tend to agree with Carla that we don't necessarily need to aim at a full harmonization of the substantive law on this. Just think of negotiable instruments. I mean, the proprietary function of a bill of lading is just not uniform around the world, and trade has survived that, right? And you have the systems where the transfer of the bill of lading by itself transfers property to the goods, and those legal systems where this is not automatically the case. And those legal systems were like the British, where that would depend on agreement of the parties. The party may agree that the transfer has a transfer of title function. Now, trade has survived that. The question is, do we need to have absolute uniformity on digital assets? I'm not sure we need, and I'm not sure we are there yet. The point I say there is a need for it. And then we'll simply add one note of caution. I am a little bit concerned about, how can I put it, a discussion that would insert yet another layer of functional equivalence rules. We have the functional equivalent rules that made the electronic equivalent to the paper, right? This is the first layer. And there we try to use neutral language to make sure that we're not creating a separate set of substantive law rules. I'll only make sure that whatever works for paper works for the electronic. Now, I've been following some of the discussion related to digital assets in a way that kind of creates an intermediate concept between traditional property and as applies to these assets. The extension of the notion of control, which was developed to create the functional equivalence of possession for the electronic records, is being now put forward as a requalification to avoid referring to property and when you talk about digital assets. And I wonder whether that is at all necessary. I think these legal systems where a property of the digital asset would be possible, they should just go ahead and recognize that. And legal systems that have a difficulty with that and say, well, because it's immaterial, you cannot have property. Well, they will find a way of dealing with that. But I'm a little bit concerned about creating an intermediate layer of, you know, a semi-property notion that would be specific to digital assets, as would, you know, would to then distinguish them from physical assets. That's all. Thank you.
Thank you, Angelo. Anna, what are your thoughts before we go to Carla? Let's just hear Anna first.
So I think you asked the question of whether we agreed with the takeaway of that session, and I must say I do. I agree with the takeaway, because what it says is that full supranational unification or harmonization is actually not the aim. It's probably not only not possible, but not even desirable. Issues of private international law, therefore, will continue to be important and an essential complement of whatever one builds, because you would have the harmonized domestic laws, but not harmonized in all extent. We might not have to reinvent the wheel. This is what many of you have said, and also it was a takeaway of that discussion. By the way, I liked everything about it except the name, because fireplace or fireside chat in Rome in August. Well,
I think we were sitting next to an actual fireside.
They might have had a hard time, but so and the last point I think was also important was that at least in the phase of developing the project, some granularity is warranted, particularly looking at possibly different scenarios for the different aspects, the contractual aspects, proprietary aspects, and also clarity on the factual relationship between all the parties involved. I think this goes back to what Carla said about knowing how technology works before, trying to develop rules to regulate it.
Thank you, Anna. I'm going to go perhaps first to Carla. I see that you've agreed with most of what Anna said, but then I want to give Matthias the last word before we must move on for time. Carla, do you want to take the floor?
Yeah, mostly I just wanted to clarify my comments because I thought I was agreeing with the prompt when I said that the non-uniformity, like not needing a supranational law, didn't bother me, right? That I thought I was agreeing, like Anna, with the prompt. I tend to agree that, like I said, guidance, particularly in the private law sphere, is needed. Hence, principles are needed. I don't think, though, in response to Angelo's point about the concept of control, like I just think that the principles are extending the concept of control in that same functional way you described as paper to electronic records to a new kind of electronic records, namely controllable ones. I think that's the only difference, is that now you have new electronic records that can be controlled in a way that the other ones couldn't, and so you just extend that idea of control to those. That's all that's happening. But I don't think it's like adding another functional layer. It's just extending the old one in ways that we've been talking about. Be flexible with existing rules and concepts that we already have.
Thank you, Carla. It seems only fair to go back to Matthias.
Yeah, many thanks. So I agree. Absolute certainty cannot be given. Maybe should not be given. That's why we should not strive for uniformity or a uniform supranational instrument. But I do think that guidance on an international supranational level is warranted. Also because, and then sometimes on fundamental issues. I mean, we see courts around the globe still grappling with the question whether you can or not have property rights in a digital asset. So I think that would be a very important one, and to make it a bit more abstract, I think it would be very helpful to have an instrument, a supranational instrument that gives guidelines to national legislators how to qualify certain issues and assets, so that using the existing frameworks, legislators and practitioners know where, in which traditional box or legal category a new issue or a new asset can be put in and therefore be solved. So regarding the also where I think guidance could be helpful is the specific conflict of laws issue regarding applicable law into property law issues in the custodian investor relationship. And there I reiterate, I think that for certainty's sake, I think and considering the nature of the asset in question, I think party autonomy is the only feasible way forward that gives certainty to parties involved. Of course, there are risks there, but I think that those legal risks, as I think Kelvin referred to, are and should be dealt with under traditional laws protecting consumers where it regards choice for applicable law. So we have those rules under EU law, under US laws, which put limits to party autonomy, and they maybe even become more relevant in this context. But I think that is not the area where we should try to introduce new rules. Thank you.
Thank you. Did I see that Kelvin wanted to?
Yeah,
I
I just wanted to respond to something Matthias suggested about giving guidance to national legislatures about how to fit digital assets. One of the problems, I think, is I'm a property lawyer, really, not so much a conflicts lawyer. Property law is one of those really, really difficult subjects where you put 3 property lawyers in a room from the same jurisdiction, they can't agree what is property. It's not like contract, right? And it gets much, much worse when you start comparing across borders. So the French and the Germans, although both civil law jurisdictions, because their civil codes are structured slightly differently. The French are more flexible with accommodating intangibles. The Germans are a little bit stricter. It really has to do with the fact that no one has really come up with a satisfactory definition of property. The ones that are very loose, so common lawyers, for example, we run into a very peculiar set of problems, right? We start applying rules that are applicable to tangible property to intangibles, right? A problem which never arises, as far as I can tell, with the Germans. But the Germans then have great difficulty, and any Germanic system has great difficulty fitting all these digital assets, like in Japan, for example, the Mt. Gox case famously, this is not property because they have a particular conception of property. So I'm not sure any guidance given at the supranational level will be helpful at the national level. It might do more harm than good because, you might solve the digital assets problem, but entirely confuse the national laws on what that country's conception of property is.
I'm going to go back to Matthias for a really short riposte, and then we must move on for time.
So that's why I think, and what's the biggest challenge of drafting a supranational guidance here is to identify the problems that specific jurisdictions encounter, and then to come up with a rule, with guidance for a rule, not prescribing how in a specific jurisdiction the legislator should solve the issue, but more what the result of the solution should be, so on a functional level say what the best practice from a legal perspective should be, and then leave it to the national systems to work out how to achieve that result. But I think it is already would be a big step forward if we identify what the best rules and the difficulties would be, and give guidance on how to solve those issues.
Thank you, Matthias. Now, this is actually really interesting, but I have to move you all along because I don't have you for much longer. So if I might, I'm going to move you on to this. We have the context now, and I'm going to rely on Anna's statement that private international law is going to keep remaining relevant here. So we're going to move to rapid prototyping, and I want to start, maybe stay with Matthias, because he did talk also about party autonomy and all that. Now, blue sky thinking now, absolute blue sky, in your opinion, what private international law framework would you draw up from the issues arising from anything in the digital economy, whether assets or otherwise? And what type of framework, in your opinion, would be the most feasible and desirable? Is it work for the HCCH, UNCITRAL, or UNIDRAW, or a combination of these three? And maybe let's hear from Matthias, who's already started us on that path.
Yeah, that's a very daunting question. I would say, of course, especially in this today's audience, all three organizations working with their own, and not just saying that because you are here, but really because of the own remit and expertise in all three organizations. I think the work that has been done at UNIDRAW level for substantive issues is very valuable, and also giving the first having the first go at conflict of laws rules, but of course, and necessarily so within the scope of that instrument. So the UNIDRAW project is limited to property law issues regarding digital assets, and therefore the conflict of laws rules is also limited to that scope. And I would think that and I would think that there is much to be done in the context of conflict of laws, which would obviously be for the Hague Conference. There's more than just property law issues. There's also enforcement that we have seen. There's jurisdiction that we have seen, and not only regarding property law, but also regarding contract law and maybe also tort.
Thank you, Matthias. Carla?
So mine isn't so much about the substance as the approach. So first to answer the question, which organization? I think all three too. I think for the same reasons that Matthias said, just the combination of the expertise and the approaches I think will be necessary to tackle what is really a very large issue, the private international law framework for the digital economy. It needs all of you. That's a big thing. But the second point I'd make, I think, is that I would hope that in the approach to drawing up a private international law framework for the digital economy, that that the three organizations would be bold, that the creators of the framework wouldn't I don't know, start from how do I say? I would, as part of an approach, hope that you would first, as we've discussed this entire time, look at the issues as they are and ask whether existing law already covers it. If and when you find things that are not covered, like legitimately not covered, and I expect those things to be few, or where there are places where there are true pain points with the existing framework, that my hope would be that we wouldn't try to find answers just by, well, let's take the thing that's not working and like retrofit it to make it work, right? I would hope that we'd start from scratch, maybe in those areas, in those very few special areas, to actually come up with something new. And and maybe even take a step further and ask, like, why doesn't the old thing work for this new thing? So my literature often refers to technology as a law's magic mirror. I think that when we stop asking how does the law apply to technology, but rather we ask what does the technology reveal to us about the law, that we can find significant insights about the ways that the old approach could be changed to be better for everything else, not just for the new areas of technology that we're trying to address. So my hope would be about the approach rather than the substance of the framework.
Thank you, Carla. Kelvin?
Right, I agree with both Carla and Matthias about which organization should be involved. This is a complex issue. The more heads you have together, the more likely you are to be able to find a good solution. The most obvious, most difficult problem really is the property problem, both because property is very ambiguous and also because the lex rea citus rule that we have in private international law, that's the one that's hardest to kind of retrofit for digital assets. I also wonder whether you might want to focus not just on property in general. There are going to be, I think in the near future, a lot of international insolvencies. So that's going to be a bit of a pressing problem. So that might be something worth looking into.
Thank you, Kelvin. Teresa?
Thank you, Jerry. Just to add to the previous discussion, the previous comment that I entirely agree, particularly this idea of institutional coordination and the need to cover from the different scope and mandate of the organization precisely the area that is within this that scope. But let me just frame again your question. Your question is about private international law framework issues arising from the digital economy. That is what I think that we have to very carefully consider. Issues arising from the digital economy as a whole, many of them has been already solved in the last 2 decades. Because the digital economy includes, for instance, electronic commerce, electronic signatures, all is part of this evolving digital economy. So what I really think that is a challenge now is what I used to call the second generation of the digital economy. So what is new in these last 20 years of evolution? And is this combining effect of AI, therefore automation and autonomy, together with big data analytics, together with DLT, together with platforms. So this kind of complex technological ecosystems are what represent this second generation of this second wave of digital economy that probably need a new attention or a fresh attention from the organization in order to see what we have been discussing already, to see what is working, what is not working properly, and therefore what do we need in order to enhance the existing legal framework for this digital economy. But the digital economy as a whole is a very vague and already partially covered area by the existing rules.
Thank you, Teresa. Before we move on to the practitioners, do Matthias, Carla, or Kelvin want to add anything else? No, then we're going to move then quickly to the practitioners, perhaps to react to what's been said so far, and perhaps also raise private international law issues which you consider to be most pressing to resolve in order to ensure legal certainty and business efficacy. Perhaps let's start with Anurag.
Yeah, so, well, private international law issues, obviously the private law aspect is something which is very critical in terms of something that needs to be looked at together with the locational challenges, locational difficulties. But then there's one aspect which, from a legal profession's perspective, that I feel has not been addressed or looked at by many organizations, is the issue of legal professional privilege. And I think that's one aspect where documents being privileged and how you have a kind of a framework for that is also a requirement, I think, from a private international law perspective. Whether authentication of identity also authenticates communication, whether a transaction is a communication, and this is purely from a legal perspective, where a legal practitioner is working or advising for a digital economy on a tech platform or a framework. So from that perspective, communication has to be protected, and privilege and confidentiality, these are two issues which I feel are very important and should be included at least in some kind of a framework, because all that is privileged is confidential, but all that is confidential is not privileged from a legal association's perspective and a legal practitioner's perspective, even on a cross-border basis. And I think that's where the key requirement is needed. If there's any point coming from the association's perspective.
Thank you. Silvan?
Yeah, so I agree in the broader term that we kind of the full harmonization of everything is maybe not achievable and maybe not even aimed at. But we also see that the perspective are a little bit different by jurisdiction, what is important, what not. Like class action that Kelvin mentioned is not that important because we don't even really know it in Switzerland. So kind of, you see, if that's not in the terms and conditions, we wouldn't probably not even miss it. But in terms of really kind of of the businesses we're supporting and the companies, I mean, usually kind of their biggest issue is that they invest so much time and effort into being into business and developing it, that compliance with whatever laws is the most important thing. And so jeopardizing that would be kind of wasting all the efforts that was done before. So having this legal clarity is really paramount importance for them. So this is, I would say, it's not to be forgotten. And in that regard, kind of building like smart contracts which do amazing things and automate cross-border transactions with lots of oracles and input data coming in. I mean, there you need to kind of, that's where the pressure or the pain points come at times. Like how do you handle then data, like data protection, data privacy issues, all the other, like is the smart contract enforceable or not? And I would say kind of there are a lot of nitty-gritty details coming into that, and those are kind of the things that I think is paining then our practitioners. And yeah.
Thank you, Silvan. Before we go to the institutions, does anybody else want to react to what Anurag and Silvan have just said? No, we're good. Okay, then we're going to actually run over to the organizations and institutionally. Do you have any ideas about how these issues could be addressed and what plans for future work may address these sorts of issues that's just been brought up? Let's hear from Anna first.
Institutionally, we certainly favor the continuation and probably also the enhancement of the cooperation that already exists among the three organizations. And we already see that there is a kind of specialization going on, and with the UNCITRAL having this more umbrella rule because of all the expertise in the electronic commerce and because of the project on the taxonomy. And we are really focusing more on the proprietary aspects of the digital assets defined in a more limited way, and by the way, also insolvency is part of it. You are right, Kelvin, this is an extremely important element to be considered. And of course, we have seen that there is ample room for private international law issues of different types. So I do think that we have to consider probably also, why not, thinking out of the box methodologies to continue to discuss together as we do in other fields. So to have discussion fora and coordination fora, and this might even be another way to enhance this cooperation.
Thank you, Anna. Angelo.
Thank you, Jerry. I think I'll begin by something that no one mentioned, that would be what could be the final outcome of any of this work be. And at this stage, I can say that I don't see any hard law coming out of this. Yeah. I think it's too early. And I think it's too fragmentary in terms of the law. I mean, to pick up the comment that Carla made, I mean, and also Anna and others and Teresa and Matthias, lots of the existing law works or can be transposed, it can be applied, but then you have here and there issues that are not adequately addressed by that. Now, these issues by themselves, they don't generate an international new instrument on them because it lacks what I would call the interstitial tissue, right? That puts them together. But we are looking at something in that direction, the current work that we are doing in automated contracting, which is we're looking at the various model laws and how do they address this? Are there anything there that is new, that is not addressed properly? Would the existing model laws need an additional provision, and which way that should go? Now, the current work that you're also doing on data transactions probably would have a completely different nature. I cannot see that being ever a model law. Probably would be more like sort of recommendation for legislators. Probably any work on conflicts of law might also have that nature because, you know, it's a question of seeing to what extent lex recita applies, doesn't apply, and what else could be used instead of that. But I would also like one comment also, and I think I should start paying royalties to Carla for picking up the various comments she makes. And that I very much like this idea of, first of all, not retrofitting issues to match just to squeeze them in the box of existing law. I entirely agree with that, but also entirely agree with the idea that technology allows you to look back at the law and say, is it working? And the truth is, the main points that are not working have been 3 points and for more than 20 years. And that is privacy protection cross-border, consumer protection cross-border, and liability. And these are the 3 points on which governments across the Atlantic and North and South have not been able to agree on a common frame of reference. And that undermines confidence in trade. That exposes, I mean, the example that Kelvin has given to us exposes consumers and small business to abuse of power by corporation unilateral terms. But mainly at the end, it boils down very often to this issue: how we protect privacy and data. What's the liability for misuse of data, or for lack of data, for loss of information? And on that, we don't have an international consensus, regrettably. I mean, there is no one elephant in the room. In my view, there have been 3 elephants in the room, and these elephants have been around for about 20 years. That said, we'll focus on the sheep for the time being. We'll take care of the small animals and we'll find a solution for them. But if you want the system to really work in the future, one day we'd have to address these 3 big things. Thank you.
Thank you, Angelo, for that trifecta of elephants. Would anybody would like to react to that? Because otherwise we are really running actually close to our time, and I wanted to thank you all. But before we close, I know Teresa's word probably is vague, but just on a personal note, perhaps, what is the one word that comes to your mind when you think about the digital economy, and how would you describe it? It doesn't have to be the law, preferably not the law. Teresa, you can't use the word vague. Let's start with Anna.
I think I would, there's many possibilities. I think I would use the word evolving, and that would be a little bit also of a caveat on what we have discussed. So digital economy seems to be somewhat of a moving target, and we have to ensure that whatever we develop is not just chasing the present moment, but it's a more durable instrument or legislative framework. So this is why I completely agree with Angelo that, you know, soft law instruments are better adapted also because of this aspect of, you know, trying to adapt to something which is evolving.
Thank you, Anna. That's evolving. Angelo, your word.
Yeah, I want to repeat Anna because I agree with her, and we're only going to be more ambiguous, and I would say fluid.
That was my word.
Yeah, drink some more, Teresa. Silvan, what's yours?
Mine would be like interconnected.
Okay.
I think everything is getting more digital. It means also more interconnection and more really kind of the linkage between the different things is getting stronger and stronger.
Thank you, Anurag.
I think my word would be empowering, because it is, I mean, digital economy as such is very empowering. So yes, that's what I would say.
Thank you, Matthias.
My word would be fascinating. The digital economy itself, what it is, what it does, the legal challenges it poses, and also to have, you know, conferences and roundtables such as this one. I find it fascinating.
Thank you, Matthias. Kelvin.
Underwhelming. Much has been promised and very little delivered. Maybe it'll deliver, you know, over time. But so far, you know, report card is underwhelming.
Thank you, Carla.
I'm the opposite. I think opportunity. Again, I think the opportunity is there to prove Kelvin wrong. I think the opportunity is there to prove him right. I think the opportunity is there to evolve the law in response to it if we're bold enough to do so. But I think opportunity.
Thank you, Carla. Teresa, you have something else besides fluid?
Seriously, my word was fluid. So thank you, Angelo, because I was inspired by this idea of liquid, no, as Zygmunt Bauman describing modernity, no, liquid and fluid in the sense that it's not only changing, but also its lack of territoriality, material tangibility, materiality, and that is indeed shaking our traditional foundation of the legal framework. So, Angelo, I agree with you. Is fluid, is liquid.
Thank you, Teresa. It probably shows that you are all much more complex thinkers than I am. My word was just open. It's an economy that's open to everybody in the world. It's open to change. It's open to technology. It's open, and it makes the world more open. And that's why we have people from all over the world, from the Americas, from Asia, from Europe, joining us on this call today. Let me thank you all very much for your time and your insight on this closing panel, the Concurrent Design Facility Closing the Digital Economy Frameworks track at the HCCH CODIFI conference. We've had with us Silvan Andermatt, Director of the Swiss Finance and Technology Association, Anurag Bana, who is the Senior Legal Advisor at the International Bar Association, José Angelo Estrella Faria, Principal Legal Officer and Head of the Legislative Branch of the International Trade Law Division, Office of Legal Affairs, United Nations, UNCITRAL, Matthias Haentjens, Professor at the Faculty of Law, Leiden University, Kelvin Lowe, Professor at the Faculty of Law, National University of Singapore, Carla Reyes, Assistant Professor of Law at the Southern Methodist University Dedman School of Law, Teresa Rodriguez de Heras, Ballell, Professor of Commercial Law, Universidad Carlos III de Madrid, and Ana Veneziano, Deputy Secretary General of UNIDOA. Thank you so much for spending your afternoon with us, your morning, your evening, I think late at night for some of you. It's been wonderful having you. And we look forward to more conversations. There will be that duking session between Carla and Kelvin, which I look forward to. But thank you so much for being with us.
Thank you.
And thank you.
Bye.
Thank you.
Bye-bye.
Thank you so much.
Thank you so much.
Bye now.
Thank
Great
you.
pleasure. Bye-bye. Bye.